Teams and arbitrators, we will be waiting for another arbitrator, Mr. Rivanta, and our session will begin. Kindly wait for a while. Thank you for your patience. Good morning, Mr. Rivanta. Can you see me and hear me?
Let's see. I can't actually see you. So I wonder what's going on.
If that's the case, may I direct Mr. Rivanta to the bottom left of the Zoom meeting? You may see a camera icon.
Actually, I can't. Okay. Yeah, I can see you now.
All right.
Except that. Okay.
All right.
Thank you.
You're welcome, Mr. Rivanta. Good day from Malaysia. Teams and arbitrators, thank you for joining with us today and welcome to the final round of the International Commercial Arbitration Moot Championship ICAMC 2021. My name is Wong Chiong and I'll be acting as a bailiff for today's session. The match will begin shortly. We will now proceed to the dry run session. Hi, lead counsel from claimant. Can you see me and hear me?
Yes, I can.
Thank you.
I can't see them.
Dr. Mary, you may click on the, may I direct you to the upper right of the Zoom meeting?
Yep.
You may see standard, you may see a column icon with view. And
no, I'm using an iPad. And so when I use an iPad, I think the options are less.
Oh, if that's the case, may I direct our technical team to address
no,
the issue?
I'm just carry on. I think what I might do is just carry on, please.
Right, sure. The counsel from respondent, can you see me and hear me?
Yes, I can.
Right, thank you. Second counsel from claimant, can you see me and hear me?
Yes, I can. Thank you.
Thank you. Second counsel from respondent, can you see me and hear me?
Yes, I can. Thank you so much.
Thank you. Good day, Honorable Dr. Mary. May I confirm that you can see me and hear me?
Well, I can only see you. That's my complaint. I normally have a tablet where I can see everybody. I think it's because you are on sharing of screen, right? You're sharing content. Yeah. When you share contents, you exclude the rest. Carry on, please. Thank you. I can hear and see you. Thank you.
All right. Thank you. Thank you, Dr. Mary. So, Mr. Ravanta, may I confirm that you can see me and hear me?
I can. Yeah.
All right. Thank you. Miss Crystal, could you see me and hear me?
Yes. Okay. Right, thank you.
Thank you. That's the end of our dry run session. Teams and arbitrators, for your information, the hearing is being broadcasted on our ICAMC Facebook page. First and foremost, I'd like to congratulate Team 1010 from Advanced Tertiary College and Team 1011 from Kathmandu University School of Law for making it to the final round. We will now proceed by inviting the counsels of the claimant and respondent to discuss on the procedural timetable for today's hearing.
Good morning. Can we go like first the respondent from the first counsel will address the question number A regarding jurisdiction. Then first counsel from the claimant. Then second counsel from the claimant and the second counsel from respondent will address the question B and C regarding the merits. Is it okay?
Very well.
And then rebuttal.
Very well.
Thank you.
Thank you, participants. May I request the counsels to stipulate and discuss detail in the chat box according to the format which has been sent by my colleague just now.
Bailiff, this is still part of the dry run, or later on when they start their submissions, they would remind us of their respective allocation and utilization of time?
For your information, Dr. Mary, they are now stipulating their time allocation plan in the chat box. I will now repeat their allocation plan to you. So from the respondent team, their first counsel will be speaking for 60 minutes, while the second counsels will be speaking for 22 minutes, and their rebuttal session will be 2 minutes. Whilst for the claimant team, the first counsel will be speaking for 12 minutes, second counsels will be speaking for 23 minutes, and they'll reserve 5 minutes for rebuttal.
What about Ms. Priyanka Priyansi raised the fact that she will be specifically what she will be touching on.
I'm so sorry, Dr. Mary. Could you come again?
Priyansi actually had indicated the order of issues they are going to address. So is she, so when she indicated that, does that mean that when we actually start the hearing,
yes,
they will not be telling us that again? So we have to listen hard on what they're doing. Good morning, Crystal, and good morning, Rebenta. I am Mary. Good morning.
Hi, Mary. That's very pleased to meet you.
And to you. We haven't met. Crystal and I know each other. Sorry, we haven't had a chance. We normally go into a judge's room and chat, but that's all right. Okay.
Right. Sure. Of course.
That's my question. I hope I wonder whether you share my concern.
Yes, Honorable Dr. Mary. They will not tell again, but they will.
All right. So please tell us again. Then, Priyansi, would you just run through that part again, please? It was quite quick.
Sure, Madam Arbitrator. First and foremost, the respondent from First Council, that is me, we will be addressing question number A regarding the jurisdiction, procedural issues mainly. And then the first counsel from claimant, then second counsel from claimant will be addressing the BNC, merits of the dispute, and second counsel from respondent. And then
all right.
All right. Thank you, Honorable Dr. Mary. Teams and arbitrators, before this session begins, I would like to provide a brief of the rules. First, each team is allocated maximum 40 minutes to submit their issue. Second, participants, you are kindly reminded to mute your microphone when you are not submitting and kindly keep your camera on at all material times. Mr. and Madam Arbitrators, we have already privately messaged you the score sheet link using the chat box. Could you please click on the link and see if it can direct you to the Google Drive? May I confirm that Dr. Mary and Mr. Rivanta can retrieve the score sheet?
Yes, I'm at the I've got to the Google Drive.
Sure.
I've got a hard copy, and I will do the necessary when I returned it.
Sure. Sure, Dr. Mary. All right. That's the end of our briefing of rules. Thank you, arbitrators. You may fill in the score sheet throughout the session, and should you have any inquiries, feel free to seek clarification from us. Participants and arbitrators, thank you for joining with us today, and welcome to the final round of the ICAMC 2021. We are honored to have Honorable Dato Mary Lim Kiam Swan as the presiding arbitrator, followed by Mr. Rivanta Sinitambi and Ms. Crystal Wong Wai Chin. The match between Team 1010 from Advanced Tertiary College and Team 1011 from Kathmandu University School of Law is now in session. The arbitral tribunal may now progress the arbitral proceedings. Mr. and Madam arbitrators, you may have the floor.
Good morning, and to my fellow arbitrators, and good morning to counsel. We are ready to hear you, and would you like to address? Can I just check with my fellow arbitrators? Mr. Evanda, are you good?
I'm fine, thank you, Dato.
All right, Ms. Crystal?
Yes, I'm good.
Thank you. Right, we don't have any preliminary issues that we want to raise with them? No, we don't. Right, good. All right, we're ready to go. Please proceed.
Thank you, Madam Presiding Arbitrator. So, respected members of the tribunal, esteemed colleagues, good morning. My name is Priyansi Podal, and I, along with my co-counsel, Ms. Alankrita Upadhyay, and my bench counsel, Ms. Yubi Shrestha, will be representing respondent in today's dispute. From the side of the claimant, I would like to introduce my fellow counsels, Ms. Clarissa, Ms. Radhashri, and Ms. Yu. If this tribunal is well versed with the facts of this case, the counsel would like to move to the issues.
Oh, I think we are. We'll get straight to the issues.
Thank you, Madam Presiding Arbitrator. Before my co-counsel addresses the merits of this dispute, there are certain procedural issues which this tribunal must address, and in that frame, the counsel has two submissions. First and foremost, vows model law is the governing law of the arbitration agreement, and secondly, the tribunal does not have the jurisdiction to hear the dispute. In the nexus of governing law of the arbitration agreement, the counsel strongly believes that the governing law for the arbitration agreement must be same as the law applicable in the main contract. First and foremost, the counsel would like to point out to paragraph 9 of the problem, Article 13, Dispute Resolution Clause, sub-article 1. Is this tribunal with the counsel?
Yes, we are.
Where it has been explicitly or clearly mentioned that the law governing the underlying contract is vows model law. In that frame, first and foremost, the counsel would like to refer to the case of Enka versus Chubb, where the Supreme Court held that where the parties have agreed a choice of law in the main contract, this should be generally treated as a choice of law for the arbitration agreement. In case of absence of choice of law governing the main contract, as a default rule, seat of arbitration is relied upon. Further, the counsel would also like to take the reference of Kababji Sal versus Kaut Food Group, which held that a choice of governing law for the main contract can amount to an express choice of law for the arbitration agreement, and in such circumstances will not be displaced by the party's choice of an arbitral seat in a different jurisdiction. Now, the counsel would like to take the tribunal back to paragraph 9, Article 13, sub-article 1, where it has been clearly mentioned that the construct shall be governed by the law of vows. Relying on that, as there is express choice of law in the law governing the underlying contract, that is law of vows, so forth, the law governing the main contract should extend to the arbitration agreement. Secondly, the notion of separability, the counsel strongly believes that the notion of separability does not in any manner forbids from the appliance of law of contract in the arbitration agreement. In this, first and foremost, the counsel would like to refer to Unicitral Model Law, Article 23, 1, sub-article 1, where it has been clearly mentioned regarding the doctrine of separability, where it has been said that arbitration agreement is independent agreement and that the invalidity or non-existence of the main agreement does not directly make the arbitration clause null and void. In this, the counsel would like to refer to the case of Sulamerica Sia National de Sergius versus NSA and Haria, where it was observed that the only purpose of doctrine of separability is to give legal effect to the parties' intention of resolving disputes through arbitration and not to protect the arbitration agreement from the substantive agreement. Further, the case of BCY versus BCZ, which held that on the doctrine of separability, a party cannot avoid the obligation to submit a dispute to arbitration. However, it does not mean that because of this doctrine, parties intended to enter into an arbitration agreement that is independent of the underlying contract. Yet,
what about, counsel, the presence in clause Article 13.2 that the arbitration is to be resolved according to the AIEC rules? Would that temper the construction that you have just given?
Thank you, Madam Presiding Arbitrator, for the question. The counsel would like to say that in the instant case, it is not the validity of the main contract or the arbitration clause that is in dispute. Rather, the question is something different. Madam Presiding Arbitrator, the question is whether the law applicable in the main contract is applicable in the arbitration agreement or not.
Right.
And so forth. The notion of separability does not in any manner forbid from the appliance of the law of contract in the arbitration agreement.
Yes, but while you make that assertion, and I think we have no quarrel with that principle, I think what has not been pointed out is whether there is any difference, substantial or otherwise, between the laws of vows, LRET, or the AIC here in Malaysia, where we are at the moment hearing the proceedings. Is there a substantive difference between the laws here? And we're looking at lex arbitri.
Madam Presiding Arbitrator, can you please repeat your question again?
My question is there a difference, substantive or otherwise, between the law of vows, LRET, or AIAC on this question of deciding on the jurisdiction of this tribunal, which is a very important question?
Madam Arbitrator, thank you, Madam Presiding Arbitrator, for your question. The Council believes that the interpretation of the pre-arbitral clause is different in the state of vows and the state of LRAD. And so forth, it affects the jurisdiction of the tribunal. Can the Council proceed, Madam Presiding Arbitrator?
Yes, please. Yes, please.
Thank you, Madam Presiding Arbitrator. So moving on to the second submission, which is the tribunal not having the jurisdiction to hear the dispute. The Council, first and foremost, would like to point out that the pre-arbitration clause, which the claimant has been a subject to, is mandatory in nature. First, relying on the principle of pacta sunt servanda, which clearly says that the contract that has been commenced between the parties must be kept. Here, as we can see, the Council firstly would like to lead the tribunal to paragraph 9, sub-article 2, article 13, dispute resolution. Is the tribunal with the Council? Yes. Thank you, tribunal. Where it has been clearly mentioned that about the exhaustion of 30 days pre-arbitral amicable dispute settlement between the parties before coming to this tribunal. So clearly, as we can see, the discussion was initiated on 10th March 2021, and the claimant came to this tribunal filing for a request for arbitration on 20th March 2021. That's just 10 days of exhaustion. And it is clear, it has been clear that the contract has not been kept. Further, the Council would like to move to the case Open Operations UK Limited versus Invesco Fund Managers, where the judge, O'Farrell, has said that the courts will enforce contractual dispute resolution procedure and give parties every opportunity to settle dispute before pursuing litigation, and also has regarded the clause as a true condition precedent, and the court will not usually permit an action to be brought in breach of such an agreement. So relying on this, the Council would also like to point out to the principle of party autonomy. Like, the parties were free to determine the procedure that should be followed by the tribunal and the parties, that they had clearly consented and signed the agreement. In this, the Council would like to further say that the claimant in approaching this tribunal has superseded the arbitration agreement, and thus it has led to premature arbitration, which in turn harms the right of my client. Pursuant to sub-article 2, as the Council has already mentioned, article 13 of dispute resolution clause, referring the matter to the jurisdiction of the parties for amicable discussion for 30 days was a pre-arbitral step. It is mandated that pursuant to sub-article 2, article 13 of the dispute resolution of Ultra Solar Project Agreement, the dispute that arose from the contract or the breach or anything else had to be referred to an amicable discussion among the parties. In the circumstance where the parties do not reach any conclusion within 30 days, thereafter the matter can be forwarded to this tribunal. Therefore, it makes it incumbent that the matter should be referred to the jurisdiction of the parties first. And the purpose of referring the matter to the jurisdiction of the parties, the aim was only one, that was to reach an amicable solution between the parties. That only after the failure of the same, the matter could have been referred to arbitration. Otherwise, it may lead to premature arbitration. Henceforth,
who decides, Council? Who decides on the prematurity or otherwise of the jurisdiction of this tribunal? We decide, or do we have to go somewhere else?
Madam Presiding Arbitrator, that is something that the tribunal decides. And
because you say that we don't have jurisdiction. So if you say we don't have jurisdiction, how do we then begin to answer this question that it's premature? Has somebody else to answer the question? So are we competent to decide on our jurisdiction?
Madam Arbitrator, thank you, Madam Presiding Arbitrator, for the question.
It's all right. It's all right. Don't have to thank us. These are arbitration proceedings, so you must relax.
Arbitrator. So, as we can refer to the paragraph 25,
yes,
it was said that first, the matter of jurisdiction will be resolved between the parties, and 3 questions that was sent, that was the hearing agenda between the parties. So as per that, the council believes that tribunal should decide whether they have the jurisdiction or not. And in this case, the agreement that has been clearly signed between the parties, the terms of the agreement has not been fulfilled.
All right. Proceed, please.
Yes, thank you, Madam Presiding Arbitrator. Now, as the council is going to conclude the submission, is there anything that the tribunal would like to ask to the council, or can the council be of any further assistance to the tribunal?
My fellow panelists?
I'm good for now.
All right.
Likewise, I'm good. Thank you.
There is a provision in the Arbitration Act of Malaysia, if I'm not mistaken, for the tribunal to refer such question to the court. Should we explore that particular venue? Remind me, Crystal, that there is such a provision, isn't it?
Yes, there is such a provision, but I think what council, perhaps for the respondents, probably mentioned or should have mentioned, I think is, I wanted to ask about the competence principle in the business council for the respondent who assist us.
Yes. All right. Well, we don't have any other questions and concerns. We've intervened. I've intervened quite. Hopefully, you haven't derailed you. Thank you very much.
Madam Presiding Arbitrator and the tribunal, as now the council strongly believes that the law governing the arbitration agreement must be same as the underlying contract, that's spouse model law, and the pre-arbitration clause that has been set between the parties is something that's compulsory before coming to this tribunal, and the exhaustion of that is compulsory before coming to this tribunal. So thank you very much.
But perhaps I could just ask you one final question. Should this tribunal then answer that very important threshold question first, as you say, it's compulsory or mandatory? Should we answer that first, make the necessary orders before we hear the rest? We shouldn't bifurcate, is it? We must hear everything together. Which is more practical?
The council believes that, thank you, Madam Presiding Arbitrator, for the question. The council believes that the tribunal must hear procedural issues as well as merits before deciding.
Thank you.
Thank you.
Madam Presiding Arbitrator and panel of arbitrators, my name is Clarissa Dawson, counsel for the claimant Future Unix Solar. Together with me here is my co-counsel Radhashri Kumarasamy and our bench counsel, Yu Siu Jing. On behalf of the respondent, we have Zoka Green Energy Limited. Today, I will be dealing with the first issue, and my co-counsel will be dealing with the second and third issue, as stipulated in the moot problem, paragraph 26. Beginning my submissions on the first issue on whether the arbitral tribunal has jurisdiction to resolve the dispute between the parties, the claimant has 2 points to make. Firstly, the law of Elirat shall govern the arbitration agreement. Secondly, the tribunal has jurisdiction to resolve this dispute. Firstly, the claimant submits that the procedural issues shall be governed by the law of Elirat. Parties did not expressly stipulate the law governing the arbitration agreement. As a result, in the absence of an express choice of governing law for the arbitration, it is best to refer to the close connection test outlined in the case of Sulamarika versus Anessa Engenharia 2012, which establishes which law should apply when none is explicitly stated. Lord Justice Mobic of the Court of Appeal maintained the principle that where there is no express or implied choice of law, the arbitration agreement will be governed by the law in which the agreement has its closest and most real connection. In our case, the seat is known to be the closest and most real connection to the arbitration agreement. Moreover, the seat has already been finalized by both parties, which is Elirat. This is seen in the Dispute Resolution Clause, paragraph 9, article 13, sub 2 of the moot problem. Therefore, the law of Elirat shall govern the arbitration agreement. In our case, the seat is known to be the closest and most real connection to the arbitration agreement.
By the same principle, the law of contracts, which is chosen to be Varros, it could arguably be the same as well, isn't it? Both of you have cited the same authority, and surely that same authority can't spawn two different conclusions. What's your response?
My apologies. In response towards your question, Madam Presiding Arbitrator, according to the case of Sulamarika, yes. Lord Justice Mobic specifically stated that the implied choice is not to be suitable. Therefore, he did regard that the closest and most real connection to the arbitration agreement shall the law. May I rephrase?
If you look at perhaps to assist and clarify my concern, if you look at paragraph 9 and at the critical clause 13, both the law of vows and the seat of arbitration, Elirat, are provided in subarticles 1 and 2. Could that principle, as pronounced in the Sula's case, apply equally persuasive, the close connection test apply, since both the law of vows and Elirat are expressly mentioned? Is an equal choice here?
Madam Arbitrator, may I further cite a case that clarifies the case in Sulamarika?
Yes.
Okay. It was held by the UK Supreme Court in the case of Enka versus Sharp that stated, in the absence of a choice by the parties, where the law applicable to the main contract differs from that of the seat, it is the law of the seat that governs the validity and the scope of the arbitration agreement.
Well, should we pay any heed to the English cases? They are not model law at all. And we are now dealing with parties who are all model law parties.
In response towards your question, Madam Arbitrator, these cases are to be known as persuasive.
Thank you.
May I proceed?
Yes, please.
Okay. The law of Elirat has adopted the UNCITRAL model law on international commercial arbitration with the 2006 amendments. Therefore, the principles of the UNCITRAL model law shall apply.
All right.
Moving on to my second submission, the claimant submits that the tribunal has the jurisdiction to resolve the dispute between the parties. Firstly, there is an applicable arbitration agreement. Despite the non-fulfillment of the pre-arbitration clause, the tribunal still remains to have jurisdiction on the resolving disputes between the parties. Referring to a case of Ravindra Kumar Verma against BPTP Limited 2014, it was held that a prior requirement to be complied before seeking reference of disputes to the arbitration is only directory and not mandatory. To further substantiate, in the case of Metcalfe versus Clipston 2004, Master Campbell decided that the word shall does not impose such an obligation. On the contrary, Master Campbell suggested that shall as the meaning of ought to, which is not the meaning as has to or must. Furthermore, it was similarly decided in the case of Chowdhury versus Kingston Hospital 2006 that shall does not mean must, and that the ordinary meaning of the word shall does not demand compliance. In our case, with reference to the Dispute Resolution Clause, Article 13, Sub 2, the word shall has been used. Therefore, it reflects its non-mandatoriness.
What about the fact that the parties in their first draft did not have this pre-arbitration condition? It was subsequently negotiated and then agreed, and the clause is as it stands today, and it was agreed to by your client. So does that change the color of your argument?
Madam Presiding Arbitrator, may I clarify that you're referring to paragraph 8?
Yes, in the first draft, there wasn't such a provision. It was straight to arbitration, but subsequently in the negotiations, then they came up with 2 subclauses. So this finally is the draft, is the agreement between parties, and it is quite emphatic in its language. It talks about parties having to amicably resolve first, and then it goes on to talk separately about the time period. Does this change the construction? And that's at the end of the day, a matter of constructing and trying to determine the intention of parties. That arbitration, I think the parties are in agreement that we have jurisdiction to decide on this very important question. But does it therefore deprive you, because you have not met the precondition, it deprives you the right of making your further submissions on this matter? That the argument that you had suggested, relying on the authorities, that the word shall are not mandatory, that is only directory. But my question, sorry, is, can we look at the background facts?
In response towards your question, Madam Arbitrator, that will be explained in my further submissions, which I'm going to right now.
All right, please. Thank you.
The model law of Elirat does not recognize the 30 days pre-arbitration clause as a mandatory requirement. Moreover, Elirat and VOWS have different reasons in interpreting pre-arbitration clauses. This is seen in paragraph 29. We did agree on it initially, but it was only a preferred but not mandatory. We do agree that we did not complete such a period of 30 days. However, we do have our own reasoning. For the respondent to dispute that it is mandatory and it should have been carried out completely for arbitration to commence is unreasonable. Reason being, if the respondent wants to insist on the completion of 30 days in the beginning of negotiations, they should have been more open and forward with trying to find a solution rather than providing fault on the claimant.
All right.
The respondent insists that this arbitration agreement is inapplicable because the party has failed to utilize the 30 days as agreed. But the issue here that the request for arbitration was filed on 20th March. This can be seen in paragraph 20. Now, we are already in May, which is more than 2 months, exact 70 days. And there is no form of communication between the parties. In fact, the last attempt to negotiate made by the claimant, which was 10th of March, paragraph 19, and parties couldn't reach any consensus. And the respondent is insisting on something that has lapsed to challenge the tribunal's jurisdiction. It should be noted that we are not against the pre-arbitration clauses, but specifically against the mandatoriness of it.
I see.
Pre-arbitration clauses are mostly helpful, but not in our case, especially in situations like this, where parties could not even agree on a governing law to apply, and the magnitude of the transaction involving several billions. We did try to negotiate, but the negotiation led to no outcome, and the longer we dragged, it could incur greater loss. Moreover, this is strictly not only a contract between us, but it also concerns a project for electrical power to be supplied to 91,000 homes.
All right. So you're saying that by reason of paragraph 19, there was no need to wait out the time period of 30 days. The writing was on the wall. It was pretty obvious you were getting nowhere.
Yes.
All right. Thank you.
May I conclude, Madam?
I'm just curious, how would you word Article 13, let's say, if the word shall not mandate a settlement negotiation within 30 days? How else would you word Article 13 to make it a mandatory clause, mandatory settlement negotiation clause?
I'm sorry, Madam Arbitrator, I couldn't hear you.
Can you hear me?
It's a bit,
muffled.
It's not that clear, Madam Arbitrator.
Okay, I'll speak louder. I'm just wondering, earlier you submitted that notwithstanding the word shall in clause, in Article 13, sub-Article 2, that this is still an optional clause for the purposes of settlement negotiation. So I'm wondering, how else would you word it to make it a mandatory clause, mandatory condition precedence in this sense?
In response towards your question, Madam Arbitrator, just to clarify with you, are you asking that how is it mandatory?
How would you word it to make it mandatory? Because you say that notwithstanding the choice of word shall, it would still be an optional clause. So how else would you word it to make it a mandatory arbitration, mandatory pre-arbitration negotiation clause?
Or it would mean, following from Crystal's question, that it doesn't matter what kind of words you use, no matter how mandatory, shall, must, etc., it wouldn't make any difference, because at the end of the day, they are all directory. You can ignore it. Is that the claimant's position?
Yes.
So it doesn't matter. So what function, according to the same authorities you're relying on, what function will have these pre-arbitration clauses? Do we now make a decision to say that parties don't bother with these clauses because they are of no effect?
Madam Presiding Arbitrator, may I have a moment to gather my thoughts?
Yes, sorry. I think we probably rained on you.
No,
Ravindra, you're not going to add on, are you?
No, I'm not at this stage. Thanks.
In response towards your question, Madam Arbitrator, the purpose of a pre-arbitration clause is basically that parties should solve their dispute by negotiation. We have tried solving by negotiation, and the parties, the opposition, which is the respondent, did not cooperate. And therefore, if it's not being solved in a simple negotiation-friendly manner, we are going to take, the cost is even going to be even more bigger if we do not solve it in this instance.
So to answer the question that my fellow panel arbitrator has asked, there would be clauses. Can you word this better? Can you change, would drafting the clause in even tighter language, would it make a difference?
Yes, Madam Arbitrator.
I see. Crystal, you're good with that? Okay.
To sum up, the arbitration agreement and its interpretation will be governed by the ELIRAT law. Furthermore, because pre-arbitration clauses are not necessary under ELIRAT's model law, the tribunal does not lack the jurisdiction to resolve the dispute between the parties. If I may be of no further assistance to this tribunal, I thank the panel for its time and indulgence. Much obliged.
Thank you. Response, please. Priyansi, you're responding now. She's muted. I can't hear her.
As what we've agreed now, the second counsel from the claimant will go first.
You're not responding on that first point. You're going to respond it towards the end, is it?
Yes, yes, Madam Presiding
All right.
Arbitrator.
Thank you. So we go, because I thought that was how it was going to be. So who's going to speak next? Claimant?
Yes, Madam Arbitrator.
Yes.
Panel of arbitrators, my name is Radhasri Kumarasamy, the second counsel for the claimant, Future Unix Solar. As stated by my co-counsel, I'll be dealing with the second and the third issue. And the claimant's stances are, under the second issue, the oral variation is invalid, and under the third issue, there was a breach. I will now begin with my submission proper. Beginning with the second issue, I have two submissions to make. First, the oral variation is invalid. And second, there is lack of conformity of the goods. In regards to the submission that the varied agreement is invalid, I intend to bring this panel's attention to the United Nations Convention on Contracts for the International Sale of Goods, CISG, and UNIDROIT Principles of International Commercial Contracts of 2016. The most relevant provision under the CISG is Article 29. Article 29, Section 1 states that a contract can be modified simply by the parties of agreement. And Section 2 provides a written contract containing a provision requiring any modification by agreement to be in writing may not be changed in any other way unless the other party had relied on it. This is similar to Article 2.1.18 of the UNIDROIT Principles of 2016. I would like to draw the panel's attention to the moot problem, paragraph 12.
Yes.
When the first oral agreement was made, despite knowing that this was not what the claimant desired, the respondent informed the claimant that they would only be able to supply 5,000 photovoltaic panels. The claimant was required to give an answer on the spot without being given enough time. Every rational person in a commercial transaction will need enough time to make a decision on something as important as this, as it would affect the claimant's reputation and the Ultra Solar project. However,
Counsel, may I ask a question?
Sure, Mr.
Isn't it true that the parties proceeded to perform the oral agreement?
My apologies, Mr. Arbitrator. May I seek further clarification?
Yeah. So my question is, the claimant contacted the respondent about the respondent's default. In that context, the respondent said, I'm sorry, I can't deliver my original undertaking. And following that conversation, while it's true that they didn't write down the agreement, didn't they follow through with that agreement in practical terms?
Mr. Arbitrator, according to the facts of the moot problem, there were actually two oral agreements made. The first oral agreement was in the paragraph 12 of the moot problem. However, the next day, the respondent had informed the claimant that they will be able to supply 10,000 photovoltaic panels with a condition that half of the photovoltaic panels will be supplied from the second branch. And I will further discuss this in my submission, Mr. Arbitrator.
I'm
I
just
answer
trying
your question?
to understand. So you also submitted that the agreements to be valid had to be in writing.
Yes, Mr. Arbitrator.
My question was, although the agreements weren't in writing, the parties followed through with the agreement, didn't they?
Mr. Arbitrator, I actually have 3 arguments for this oral variation. First,
okay, please proceed.
First, the claimant had no other practical choice. Second, the non-oral modification clause is effective. And third, the assurance that the respondent had given that the photovoltaic panels, the 5,000 photovoltaic panels from the second branch will be of the same quality as the other 5,000 is not conforming to the contract. So that is our argument, Mr. Arbitrator. And
but
that,
do those arguments all go to the question of the validity of the oral agreement?
yes, Mr. Arbitrator.
They do.
We are arguing that the oral variation is invalid, Mr. Arbitrator.
Okay.
May I proceed, Mr. Arbitrator?
Yes, please. Yes, please.
But as a follow-up to that question, do these changes, variations, so to speak, have any part to play or effect on the validity of the contract? I mean, or are these just execution, the manner in which the contract itself was being executed? Because the contract was about 10,000 solar panels to be delivered by X date. At the end of the day, your client got the 10,000 panels, albeit late, and from different sources. But are we making much ado about nothing? Because at the end of the day, quality aside, is this really a material question to address that there is oral variation? Is it just the manner in which the substance of the contract was being carried out, which is about 10,000 solar panels?
Yes, Madam Presiding Arbitrator. The claimant had actually received 10,000 photovoltaic panels as agreed in the initial contract. However, in the oral agreement, the respondent had gave assurance that the quality will be of the same, and we agree of that. However, there's another matter that we have to take into account, that the claimant had no other practical choice because the respondent was the exclusive provider.
Yes.
Therefore,
so the variation, oral variation, really is neither here nor there, because at the end of the day, they're still not giving you, while they gave you 10,000, they didn't give you the 10,000 of the quality that they promised to give. Isn't it?
Madam Presiding Arbitrator, yes, we had obtained all the 10,000 photovoltaic panels, but not of the same quality because there were issues.
And that's got nothing to do with the variation. That's back to the principal contract. The variation, while the variation was about how they would deliver the 10,000, they always promised to meet the same quality, which is the primary contract. So is this really the argument about validity of the oral contract? Really, at the end of the day, much ado about nothing?
Yes, Madam Presiding Arbitrator, because I agree that we agree that in the initial contract, it was stated that they will deliver 10,000 photovoltaic panels, and yes, they did fulfill their obligation by delivering 10,000 photovoltaic panels. However, it should be noted that in the oral variation, it is not only the changes in the branch, but also the extra assurance that they had give us.
So you want that extra assurance, or you don't want the extra assurance? But you can't have the extra assurance if you argue that the oral contract is invalid.
Madam Presiding Arbitrator, it's actually on them because they had gave the assurance.
But that's in the oral contract, which you are maintaining is invalid.
Yes, Madam Arbitrator. However, I would like to emphasize the point that the claimant had no choice but to agree.
You do have to take a legal position here because you can't approbate and reprobate.
Yes, Madam.
All right, we move on, please. Thank you.
Much obliged. However, the respondent told the claimant the next day that they would be able to supply 10,000 photovoltaic panels, but half of them would be supplied from the second branch. The claimant had no choice but to accept because this is also not what they agreed for, having the other half of the supply from the second branch. However,
Counsel, is there anything in the original contract that requires the photovoltaic panels to be produced in a particular place?
Mr. Arbitrator, in the original contract, it was not specifically stated that it will be delivered from the state of Wales. However, their first branch is in the state of Wales.
Okay, thank you, Counsel. That clarifies my question.
To further substantiate my argument, reference would be made to the 2018 case of Rock Advertising and NWB, where the non-oral modification clause was found to be effective mainly because of commercial certainty. In this case, Lord Sumption had stated that although parties have freedom to make contracts, such autonomy operates up until the point the contract is made, and thereafter only to the extent that the contract allows it. To the question of whether it should be inferred that parties who agree an oral variation, regardless of a non-oral modification clause in their contract, must have intended to dispense with the clause. To this point, he found that by including a non-oral modification clause, parties have agreed that the oral variation will be invalid. The natural inference is not that the parties intend to dispense with the clause, but that they have overlooked it. By making a conclusion from this case, it is evident that the parties included the non-oral modification clause in the contract. And as a result, the given facts of the moot problem demonstrate that they did not intend to dispense with the non-oral modification clause. As a result, there is no reasonable basis to demonstrate why the non-oral modification clause is ineffective. The essence of this argument, panel of arbitrators, is that the existence of the non-oral modification clause in the contract is effective. It is thus an invalid oral variation. The claimant's second submission for the second issue is that there is a lack of conformity of the goods. The most relevant provision under the CISG is Article 35. Article 35, Section 1 states that a seller must deliver goods which are of the quantity, quality, and description required by the contract. That is to say, panel of arbitrators, a seller can be held accountable if the goods provided did not conform to the contract. Before I commence with the issues of lack of conformity, I would like to inform the panel of arbitrators that reference would be made to the moot problem, paragraph 6 and 7, where a contract was made between the claimant and the respondent to supply 10,000 photovoltaic panels. The claimant was given a certificate that serves as a verification that the photovoltaic panels meet the specifications set forth by the local council. Therefore, in this context, there are two issues. The first issue is that the local council requires 350 megawatt as a minimum energy. However, it was discovered during the maintenance in February 2021, 60% of the electricity was not generated in September, October, and November. Nevertheless, according to the certificate, only 5% of the efficiency will be lost in the event of extreme heat. So based on the information provided, this represents a 55% difference. Moving on to the second issue.
Do we have any information as to whether this deficiency is due to which of the 5,000, the first 5,000 or the second 5,000? And this is still in relation to the oral variation clause, right?
Yes, Madam Presiding arbitrator. May I have a moment, presiding arbitrator? Madam Presiding Arbitrator, it was evidently stated in the moot problem number 16, paragraph 16.
Yes. That what? It came from the second branch.
Yes, Madam Presiding Arbitrator.
Thank you.
Much obliged. Moving on to the second.
Sorry, counsel. If your answer is that it's in relation to the second batch, but if you look at clarification on moot problem number 11, no certificate was provided for the 5,000 panels that came from the second batch.
May I seek further clarification from your question, Madam Arbitrator?
So you mentioned earlier that the 5,000 panels that was actually giving problem is the second batch, and you rely on the certificates given for the first batch. That seems to be a disconnection in terms of the certification and also perhaps the performance certificates given to the panels, because those are only in relation to the first batch, right?
Yes, Madam Arbitrator, the certificate was only for the 5,000 photovoltaic panels, which was directly from the respondent, which is in the state of BAUS. However, it connects to my first point that the assurance that the respondent gave during the oral variation, the assurance was that the quality will be of the same as the 5,000 photovoltaic panels from the other branch.
So you don't need a certificate to prove your point. Is that what you're suggesting to us?
It actually included, Madam Arbitrator, as per number 11 of the moot problem clarification.
Oh, all right. Thank you.
Much obliged. Moving on to the second.
May I ask whether the so when I read to the moot problem, I see a number of different reasons given for this the 55% reduction in power, and one of them seems to be a natural phenomenon. What is your view on the impact of that natural phenomenon?
Mr. Arbitrator, if I may refer you to number 14 of the moot problem clarification, it stated that the extreme heat is when the temperature surpasses 40 degrees Celsius and the El Nino season is overheating. It may be a supervening event and it may be unprecedented. However, it was stated in the certificate that in the event of extreme heat, only 5% will decrease.
Thank you.
Moving on to the second issue, according to the Solar Energy Research Journal, 3% of the total photovoltaic panels in the region would malfunction owing to overheating, as indicated in the paragraph 28 of the moot problem clarification. In actual, 5% of the photovoltaic panels were defective. While the sum may appear insignificant, the impact is enormous, despite the fact that 95% of photovoltaic panels are still operational. This is insufficient to meet the main goal of the Ultra Solar project. Furthermore, according to the expert analysis, El Nino season is one of the possible causes of the overheating. However, it is not the primary cause of overheating, and it is worth noting that the El Nino season happened in November 2020. As a result, it is entirely impossible to claim that the El Nino season was responsible for the failure of the 5% of the photovoltaic panels. To illustrate my argument further, I would refer to the Court of Arbitration Award number 8740, which concerns a coal supply contract. The contract specified a percentage of volatile matter of 32%. The coal delivered in the shipments had an unusually low volatility level of only 20.4%. This is so low that the defendant would have every right to reject this delivery if their cement business utilized the coal but incurred significant costs in making it usable, and they would not have incurred if the coal with the requisite proportion of the volatile matter had been delivered. The court concluded using Article 35 of CISG, because the contract provided for about 32% volatile matter and the delivered coal only contained 20.4% of such matter, there was a difference in quality and the buyer was entitled to damages. The conclusion to be drawn from this example is that while the number of defective solar panels in this instance is not significant in comparison to the case I had previously described, it had caused the huge collapse of the Ultra Solar project and destroyed its entire purpose. In brief,
where is the evidence of the huge and destruction?
May I have a moment, Madam Presiding Arbitrator?
Yes.
Madam Presiding Arbitrator, if I may refer you to number 19 of the Moot problem clarification, it stated that the failed operation was due to the malfunctioning photovoltaic panels.
That is following from paragraph 17. Paragraph 17 of the original problem, that it was a question of putting total blame on who to put the blame on, and it's for the failed operation. Where is the evidence of the failed operation?
May I have a moment, Madam Presiding Arbitrator?
Thank you. The parties have assumed that the operation has failed totally.
Yes, Madam Presiding Arbitrator.
All right, thank you. I accept that. Thank you, Counsel. Please proceed.
Much obliged, Madam Presiding Arbitrator. Moving on to my third issue, whether the respondent was in a breach of its obligation to deliver 10,000 photovoltaic panels later than the agreed date. The claimant's submission for the third issue is that the delivery on time is crucial. Article 6.1.1 of the UNIDWA principle is the most relevant provision. It provides that if a date is established by or determinable from the contract, the seller should deliver the goods on that day. In February, during the initial contract, the claimant stressed the importance of the delivery date because late delivery would affect the claimant's capacity to fulfill under its contract with DAFA Local Council. It should be noted that the delivery date was communicated to the respondent. It's important to note at this point that the political crisis occurred in March, but the borders were closed in April. So it is acceptable to claim that the respondent did not anticipate that the international borders would be closed during the oral agreement. As a result, any reasonable person would expect that there would be no problem with the delivery. However, when it happened in April, the respondent did not inform or address the situation with the claimant in any way. As a consequence, the respondent delivered the 10,000 photovoltaic panels 10 days later than the agreed date. If the respondent had been able to deliver on the appointed date of 22nd August 2020, the operation of the Ultra Solar project may have begun sooner. The claimant
Why didn't you reject it when it was late, since time was so important to you? Why didn't you reject the goods when it came 10 days late?
Madam Presiding Arbitrator, if I may refer you to number 18 of the Moot problem clarification,
yes.
It was stated that the claimant was willing to make the payment since the photovoltaic panels had been delivered and supplied to them.
So when you accepted delivery and installation at that time, 10 days late, was there a waiver?
No, Madam Presiding Arbitrator.
All right. Why do you say there was no waiver?
Madam Presiding Arbitrator.
No waiver to rights, yes.
Madam Presiding Arbitrator, despite the late delivery, the claimant had accepted, but with a reminder that the photovoltaic panels are of the same assurance. However, after 5 months, when the claimant had found out there were some defects in the photovoltaic panels and it had caused the massive failure of the Ultra Solar project, That's the reason there is also a claim for the late delivery.
Sorry, just sorry, Ravida, I'll just clean up this point. So your damages here would be from the defective goods or from the late delivery?
There is also consequences faced by the claimant, Madam Presiding Arbitrator, and also the defective photovoltaic panels.
So you accept that there will be a distinction between the two types of damages that you'll be claiming for, one for the late delivery and one for the defective goods.
Yes, Madam Presiding Arbitrator.
And if that is the case, if you have accepted, and emphasizing in your response that it was because there were assurance vis-a-vis the quality, so your damages is necessarily restricted to damages on quality and nothing to do with late delivery. Am I correct?
Yes, Madam Presiding Arbitrator.
Thank you. Sorry, Ravinda, you were going to ask the question.
So that cleared up my question.
Are you? I'm sorry.
I had the same question, yeah.
You had the same question, yes.
Yeah.
Therefore, panel of arbitrators, I would like to emphasize that based on the moot problem, the claimant clearly communicated to the respondent that the delivery date is very crucial. The failure to deliver the photovoltaic panels on time is unquestionably a breach of contract. Before I conclude my submission, may I know if there's any question from the tribunal that I may address?
Wasn't there a warranty at all? I know it's not in the the moot problem itself, but this is a contract of $1 billion USD guarantee. Typical contracts of this nature have warranties and the obligation to remedy when there are such defects. Were those part of the negotiations? I'm sure this is off the moot problem. Let's just see how you respond to that question.
May I seek further clarification from your question, Madam Presiding Arbitrator?
What you know, in a typical contract of this nature, there are warranties involved. And there are also obligations under the law of contract and in the UNIDROIT principle to remedy. Was there just sheer denial and reluctance to remedy on the part of the respondent? And that's the reason why the whole negotiations failed and you went to arbitration immediately without waiting out the 30-day period.
Madam Presiding Arbitrator, I believe that my co-counsel had answered your question regarding about the arbitration agreement.
All right, thank you.
To conclude, the oral variation made between the claimant and the respondent is invalid and the respondent had breached its obligation by failing to deliver the 10,000 photovoltaic panels on the agreed date.
Thank you.
I thank the tribunal.
Sorry, one final question. We would be expected to make award on the damages?
Yes, Madam Presiding Arbitrator.
All right, if that be the case, this whole thing was triggered by the local authority pulling back on the USD 1 billion guarantee. What is the loss? What is your loss? Where did the guarantee go and what would be the loss? The guarantee or some other damages?
Madam Presiding Arbitrator, to answer your question, there are certain expected loss in terms of monetary, and also the main reason the contract was awarded to the claimant was due to the good reputation. So that is also an inconvenience to the claimant, Madam Presiding Arbitrator.
Thank you. My fellow panelists, any questions? Co-arbitrators?
Thank you, Dato. I have no questions.
Ms. Crystal?
No further question in this juncture.
Thank you. Yes, response, please.
Honorable members of the tribunal, esteemed colleagues, greetings. I am Alongkrita Upadhyay, and I will be representing the respondent, Zokwa Green Energy Limited, in this dispute. As my co-counsel, Ms. Priyanshi Paudel, clearly specified as to how this tribunal wouldn't have jurisdiction to hear the dispute, the council now would like to move towards the merits of the case. Okay. However, before heading towards the merit, the council would like to state a fact. Members of the tribunal, there are no laws that compel a party to predict the unpredictable. Basically, no laws under the international arena can make a party liable for something it was not in their hands and was completely unpredictable and unforeseeable. As a matter of fact, my client, Zokwa Green Energy Limited, has just been a victim of some unforeseeable circumstances. In order to prove the innocence of my client, the council has two submissions. Firstly, the oral variation made to receive 5,000 photovoltaic panels from the respondent's second branch Vaigari is valid, and that, secondly, the respondent is not in breach of its obligation to deliver 10,000 photovoltaic panels on 1st September 2020, which is later than the agreed date. With regards to the first submission that talks about the validity of oral variation, the council has two interrelatable arguments. Well, firstly, the council would prove that the oral variations must be effective, and secondly, the goods did confirm the qualities of the photovoltaic panels. If the tribunal if the tribunal permits, the council would like to move towards a first argument of a first submission.
All right.
Thank you, Madam Presiding Arbitrator. Firstly, regarding the oral variation, members of the tribunal, the council would like to state the principle of contractual freedom, which provides that the parties, every adult or a party can enter into a contract and set laws for themselves without any restrictions until and unless it goes against the public policy. Further, the parties' freedoms relates to both their decisions whether and with whom to enter a contract and how the contents of the contract should be. As we refer, in the oral variation that was made in the midst of March, the council submits that it is a new contract. To cite authorities for this argument, the council would like to cite the case of Commissioner of Taxation of Commonwealth of Australia versus Sarah Lee Household and Body Care, where it was held that when the parties to an existing contract entered into a further contract by which they vary the original contract, then by hypothesis, they made two contracts. Secondly, in the case of GEC Macroni Systems versus BHP Information Technology, FinJ stated that parties to an existing agreement may vary or extinguish some of its terms by a subsequent agreement. In doing so, the parties will have made two contracts with the latter no less than the former being subject to the ordinary rules of contractual formation. Thus, having said that, the council submits that the offer that was made by my client in the midst of March regarding the 5,000 photovoltaic panels to be received from the state of Vaigari was immediately accepted by the claimant, which creates an oral contract. However, the council agrees to the fact that there is an NOM clause referred in paragraph 11 of the problem, as Article 1 General of the Ultra Solar Project Agreement provides that all variations must be agreed, set out in writing, and signed on behalf of both the parties.
Council, I need to stop you there.
Yes, Madam Arbitrator.
Ravinder, you please ask.
My question was in relation to the presiding arbitrator's question to the previous council, which is, does this variation agreement, is it relevant at all?
Thank you so much, Mr. Arbitrator. So to answer your question, yes, indeed, it is relevant because the claimant in here is complaining that the 5,000 photovoltaic panels that was received from the state of Vaigari through an oral variation does not actually does not actually conform with the quality of the goods. So in order to respond for that, the oral variation indeed is a issue, Mr. Arbitrator. Has the council answered your question?
So the oral variation to the agreement was what? To deliver lower quality panels from another plant?
No, Mr. Arbitrator. What happened was, in the midst of March, there was a political turmoil due to which my client had to lose 2,000 of its workers. And as a matter of fact, in order to oblige with the contractual obligations, my client made an oral variation where 5,000 of the photovoltaic panels will be received from the state of Vaigari. However,
but 5,000 lower quality panels?
No, Mr. Arbitrator. The 5,000 photovoltaic panels conferred with the same quality of the goods. However, the claimant is claiming that the 5,000 photovoltaic panels that was brought from the second branch Vaigari did not fulfill the conditions and were of low quality. So in order to respond for that, and further, they claimed that the oral modification was ineffective, due to which since there was no oral modification clause.
You do appreciate that when you argue on variation, you are still arguing on the existence of the principal agreement, but only that the clauses, Article 1 and any other particular provisions have been varied to the terms as you now rely on. But if your proposition, and that's the proposition I believe I heard, is that relying on the Australian authority, that you effectively have made two contracts. That's not an argument on variation at all. That's an argument of the existence of two separate contracts. Now, if that's your proposition, if that's your primary proposition, where is the evidence on the existence of all the session terms of contract to bring into existence the second contract? Because all that we see in the second scenario is about the quantity and the place from which the goods were supposed to come from. So could you clarify on whether your proposition is, as I had understood, that you are not dealing with variation, you're dealing with two contracts?
Thank you so much, Madam Presiding Arbitrator, for your question. However, to answer your question, the Council is stating that there was a variation, but the variation, however, as provided in the citation that the Council provided in GC Macroni Systems versus BHP Information Technology, when the parties to a contract agreed to a variation, they by hypothesis have made two contracts. So that is the claim the Council is claiming. Shall the Council proceed?
Council,
Mr. Arbitrator.
Why was there a need to vary a contract when the original contract didn't specify a place?
Place.
Members of the tribunal, the Council would like to state that in the original contract, that it was applied that all the photovoltaic panels, which is the 10,000 photovoltaic panels, will be received from the respondent's first branch, which is located in the state of Laos.
However, you say?
Sir?
You say it was implied? You said it was implied?
The respondent and the claimant as we refer to paragraph 6 of the problem, it clearly specifies that it required 10,000 photovoltaic panels, and it was to be provided from the respondent's first branch. But since it was to be provided, the oral variation, the 5,000 photovoltaic panels had to be received from the respondent's second branch Vaigari. So that is why there was an oral modification. As a matter of
say anything about the location in which the panels are to be manufactured?
The location was indeed not mentioned, Mr. Arbitrator, but since the contract was done with the main branch, which is the respondent, the main branch whose office was located in the state of Laos.
That's my reason. That's the reason for my confusion, shall I say? You know, there was no requirement in the original contract and therefore no need to vary it.
And hence it was really a matter of how the contract was executed. And these were just discussions between parties.
Yes, indeed, Madam Arbitrator. the council agrees to that fact that it was just a variation. But however, the claimant is now contending that the 5,000 photovoltaic panels...
It's not even a variation of legal implications. It's just carrying out the contract, because you delivered and installed 10,000 panels. Where you got it from was not from a different company. It doesn't even matter if it was from a different company, so long as it was done by the respondent to your client. And there's no suggestion that it came from anybody else.
Indeed, Madam Arbitrator. However, the respondent, the council believes the respondent was in duty to inform the claimant about how the photovoltaic panels are to be are to be brought. And as a matter of good faith and as to act in their best interest, my client clearly agreed to an oral variation and therefore notified the claimant about it, which is the answer. Shall the council proceed?
Thank you.
Thank you so much, Madam Presiding Arbitrator. However, as the council referred to paragraph 11, the claimant is claiming that there is a NOM clause, which is a no oral modification clause, due to which the oral variation must be considered invalid. However, the council now would like to state the decision that was given by Lord Briggs in paragraph 24 of the case Rock Advertising Limited versus MWB Business Exchange Centers, where Lord Briggs provided three areas where the NOM clause could be valid. First, that the parties can agree to remove a NOM clause from their bargain orally. Secondly, that the oral variation to amend some of the terms would be verified and implied if they have considered the existence of NOM clauses. And thirdly, it should be a matter of necessity. In this case, if we refer to paragraph 13 of the problem, members of the tribunal, is the tribunal with the council?
Yes, thanks.
Thank you so much. So as we refer to paragraph 13, it is clearly provided that in the last line, they agreed not to sign the agreement because of the prevailing obstacles to do so, which means that they had the parties had agreed that there was a NOM clause, yet they agreed not to sign the agreement because of the political turmoil. Further, in the recent case of Charles Lim Terang, Siang and another versus Hong Chun Hao and another, in the 2021 case, paragraph 54 of the judgment clearly provides that that the parties could depart from an NOM clause via oral agreement if the parties had expressly or impliedly intended to depart from it. From paragraph 13, we can conclude that the parties expressly therefore intended to depart from an NOM clause, which is the no oral modification clauses, due to which the oral variation must be considered valid.
All right.
Further, yes, Madam Presiding Arbitrator.
No, carry on, please.
Oh, thank you so much. Sorry. Further, the counsel from the respondent clearly specified, the counsel from the claimant clearly specified the article 2.1.8 of UNIDROIT, which provides that there must be that the NOM clause there was no reasonable reliance, due to which the NOM clause must be considered effective. However, as for article 2.1.7 of UNIDROIT, it clearly provides that an oral offer must be accepted immediately. In this case, as we refer to paragraph 13, the oral offer that was made by my client to the respondent was accepted immediately, which made my client rely on the pure actions of the claimant. Further, as a matter of fact, where the claimant accepted the goods and also paid the consideration, clearly proves the intent of the claimant to be bound by the oral variation. As therefore, the oral variation must be considered effective. Now, with the tribunal's permission, the council would like to move towards her second argument of the first submission, that the goods do fulfill the were of perfect quality as required in the contract. Shall the council proceed?
Yes, please.
Thank you, Madam Presiding Arbitrator. As we refer to Article 35 of the CISG, it provides that the seller must deliver the goods that conform to the quality of the product in the contract. Now, the council would like to request the tribunal to refer to paragraph 7 of the problem.
Yes.
In the paragraph 7, it was clearly provided that the claimant was provided with the certificate of specification of the photovoltaic panels, where it acts as a proof that the products fulfill the conditions required by the local council. The council is here stating that my client did supply the goods. But if we refer to the third line, it clearly provides that to ensure efficiency of the photovoltaic panels, a regular inspection must be done every week as stipulated in the certificate. So in this case, members of the tribunal, the claimant itself is a leading solar energy supplier. It actually specializes in planning, financing, constructing, and maintaining solar power plants all around the world. The claimant, as a matter of fact, if we refer to paragraph 16 of the clarifications of the Moot problem, clearly provides that the claimant was responsible for the inspection and maintenance of the photovoltaic panels. However, the inspection was done only in the first 2 months, due to which, and after that it was not done, due to which the 500 of the photovoltaic panels happened to malfunction. The council now would like to state, yes, Madam Secretary.
Can I refer you to clarification questions 12 and 13?
Yes, Madam Presiding Arbitrator.
Okay. Yes, the main question or the main issue that I have is during the first 3 months of the perhaps commercial operation date, you have only 140 megawatts as opposed to 350, which was promised, right? And then question 13, inspection was regularly done in the first 2 months. So what was the main reason, putting aside the El Nino, which happens in November, what exactly happened in these first 3 months, which brought down the generating capacity from 350 to 140?
Thank you so much, Madam Arbitrator. So to answer your question, in the first 2 months, the El Nino season did not come up. However, in the November, the El Nino season came up, so as provided, in the end, due to the extreme heat, 500 of the photovoltaic panels malfunctioned. So as a matter of fact, the first 3 months, it was only able to generate 140 megawatts of electricity. However, in the first 2 months, when the regular inspection was done, the goods were of perfect quality and the claimant did not even question anything. Yes, Madam Arbitrator.
But perfect quality would mean 350 megawatt as opposed to 140 megawatts, right?
Yes, Madam Arbitrator. But this the report is provided in the first 3 months. So in the month of November, the El Nino season commenced, due to which 500 of the photovoltaic panels malfunctioned and the inspection was not done. So as a matter of fact, the 140 megawatt, the council is trying to say that the 140 megawatt of electricity in the first 3 months considers not just the 2 months where the inspection was done and the goods were of good quality, but also of the third month, due to which the temperature rose and the 500 of the photovoltaic panels malfunctioned.
I think it's okay. It's okay.
Yes, Madam Arbitrator. Thank you so much. The council also would like.
Can I just clarify? So the reason why you're submitting the panels didn't work up to the standard was because the claimant failed to maintain them. Is that right?
Inspect them. Yes, Mr. Arbitrator.
Inspect them and maintain them. Okay, fine. All right, thank you.
Thank you so much, Mr. Arbitrator. So now the council has clearly specified the inspection must be done and the inspection wasn't done. The council would like to state the principle of caveat emptor, which provides that the buyers must be aware. The Latin term caveat emptor gives the responsibility of any risk in the goods on the shoulder of buyer, especially if it does not inspect the quality of the goods. In this case, members of the tribunal, the claimant had done due diligence from February 2019 to February 2020. My client had, the claimant had participated in the tender process, due to which if the goods were of deferred quality, the claimant could have easily known and could have easily not accepted the goods. However, by accepting the goods and also paying the consideration, this clearly proves that the claimant, the goods were of good quality, and that the oral variation was indeed effective. Having said that, the council now would like to move towards her second submission, which is that the respondent is not in breach of its obligation to deliver 10,000 photovoltaic panels on 1st September 2020, which is later than the agreed date. However, before that, is there anything the council can clarify regarding the first submission?
No.
Thank you, Madam Presiding Arbitrator. For this second submission, the council has two interrelatable arguments as well. Firstly, the delivery date was modified when the claimant accepted the goods. And secondly, the delay in performance of contractual obligation is indeed excusable.
Yes.
Members of the tribunal under... Yes, Madam Presiding Arbitrator.
Please carry on. Carry on.
Thank you. Sorry. So as we refer to Article 29(1) of the CISG, a contract may be modified or terminated by mere agreement of the parties. Rather, modification can occur through conduct as per Article 18(3) of the CISG. In this case, members of the tribunal, the council, since the delivery date was modified, since the delivery date was 10 days later, the delivery was provided 10 days later, the claimant could have easily avoided the contract. The claimant could have easily said that it will not fulfill the obligations, the claimant could have easily returned the goods. However, in this case, the claimant clearly accepted the goods.
May I
Yes, Mr. Arbitrator.
Ask the question about the context. You say that the claimant could have rejected the goods. If the claimant did that, where would they have, how would they have been able to fulfill their contract with the council?
Indeed, Mr. Arbitrator, the council is just trying
to... what is the point of submitting that they could have rejected the goods when they clearly could not have?
Thank you so much, Mr. Arbitrator, for your question. In this question, the council would like to answer in a way where they could have at least, they could not, since the delivery date was important to them, they had clearly specified that. However, by accepting the goods, they did not even question regarding the acceptance. They clearly accepted, which clearly proves that the claimant also through conduct had modified the delivery date.
Two things. One moment. I need to do some housekeeping. We are running short on time. I will give you another 2 minutes, 3 minutes, fellow arbitrators.
That's good with me. Yeah.
All right. 3 minutes then to move on to your last point as well. Just on this point, I would like to ask you, the purpose of inspection is in relation to the operation of these panels. And surely it is only when it is in operation that one would know whether it fits, whether there are any defects. We are not dealing with defects which are patent. These are defects in the operation and the amount of electricity which is ultimately generated. And that can only be evidenced from an inspection during the operation of the panels. So do we not have to temper our propositions from the time, the relevant time? Acceptance of the goods itself is not a waiver of the quality.
Thank you so much, Madam Presiding Arbitrator. However, in this issue, the council is dealing that the delivery date was modified when the claimant accepted the goods. And regarding, and to answer your question about the perfect quality, the council would like to request the tribunal to refer to paragraph 13 of the clarification of the moot problem, which clearly provides that inspection was regularly done in the first 2 months after the Ultra Solar project began its operation, but no issues came up into light. So in this fact, Thank you so much, Madam Presiding Arbitrator.
Yes, please move on.
Thank you. So having said that, further, it clearly provides in Article, Article 30 of the CI.
We've got a new member on the tribunal, is it? Somebody's dog's participating as well. Carry on, please.
Thank you. So Article 30 of the CISG provides that the general duty of the seller involves delivering the goods, handing over any documents relating to them, and transferring the property in the goods. In this case, members of the tribunal, my client had provided the certificate of specifications, which clearly specified inspection had to be done on a regular basis. Secondly, my client delivered the goods despite having a political turmoil and losing 2,000 of its workers and fulfilled its obligations under the contract. Just because the inspection wasn't done, my client cannot be held liable. Secondly, now, the council would like to move towards her second argument of the second submission, which is that the delay in performance of the contractual obligation is indeed excusable. For this, the council would like to state the classic Roman principle of impossible nulla est obligato, which provides that there is no obligation to perform impossible things and has constituted a valid exemption to perform. In this case, the wordings of the CISG in Article 79(1) of the CISG clearly provides a four-part requirement for an exemption. First, that there must be an impediment. In this case, members of the tribunal, the impediment was the closing of international borders in the state of Laos, due to which everything was put on a halt. My client could have done nothing because there was an impediment. Secondly, the impediment was beyond the respondent's control. In this case, members of the tribunal, since it was a third-party obstruction, it was caused by the state of Laos itself, my client could not have delivered the goods because it was not in the respondent's control and it was just in the hands of the Laos. Thirdly, the impediment and its consequences were unforeseeable. Members of the tribunal, it clearly provides that both the parties could not, political turmoil would last 5 months, due to which, members of the tribunal, the impediment was beyond the impediment and its consequences were unforeseeable for my client. My client couldn't foresee that the political turmoil that started in the early April would last till the end of the August, due to which the international borders would be closed. Therefore, it was unforeseeable. And fourthly, the impediments and its consequences were unavoidable. In this case, as a matter of fact, it was a third-party obstruction, due to which it was because of the Laos government, there was the closing of international borders. My client is just a private company, members of the tribunal, due to which its consequences were unavoidable for my client. Therefore, my client should be excused as all the requirements were fulfilled as per Article 79(1) of the CISG. Having said that, the council, before concluding, the council would like to ask the tribunal if there are any clarifications the council would make to the tribunal.
No, I don't have any. Others?
I have no questions.
All right, thank you so much.
Thank you so much. Having said that, the council would like to conclude and request the tribunal to find that the oral variation made to receive 5,000 photovoltaic panels from the respondent's second branch Vaigari valid, and that to find that the respondent is not in breach of its obligation to deliver 10,000 photovoltaic panels on 1st September 2020, as it was not in their hands. Thank you so much, members of the tribunal.
Rebuttals? Rebuttals of, who's doing rebuttals, please?
It's me, Madam President Arbitrator.
Thank you. You've got 5 minutes, is it?
Yes, Madam President Arbitrator.
Thank you.
Panel of arbitrators, the claimant have few rebuttals. Firstly, in answering the question to the respondent, yes, only regular inspection was carried out in the first 2 months, but there is not only one issue, but more than that. I would like to emphasize that the El Nino season happened in November, but 60% of the electricity was not generated for the first 3 months, which is September, October, and November. It is before the El Nino season happened, an extra 200 panels were in defects than expected. It is pointless to blame on the El Nino season. And even inspection was done in the first 2 months, the 60% electricity was not generated. So it is impossible to be the fault of the El Nino season. We are aware that 5% of the photovoltaic panels are defective. However, it caused the massive failure of the Ultra Solar project. And moving on to my next point, the El Nino season effects were only apparent in February. So it is unreasonable for the respondent to argue that the claimant gave a late notice. And my fourth point is that it is not as easy as the respondent had mentioned to not accept and find a new supplier because, as I had stated previously, the respondent was the leading solar panel supplier, and especially to find a supplier who can meet the requirements of the local council. The respondent was an expert on manufacturing of the specific design of photovoltaic panels that the claimant required to make the Ultra Solar project a success. And it is true that the respondent was facing a hard time since they had lost 2,000 of their workforce and a prominent supplier. However, the respondent had gave their word that they would be able to supply the 10,000 photovoltaic panels, not only one, but on 2 separate days. So anyone in the shoes of the claimant would believe that despite the hardship, the respondent is able to fulfill their obligation. It also should be noted that they gave assurance to the claimant. The Lord Briggs assumption provided by the respondent is a dissenting judgment, and therefore it is at the expense of commercial certainty. And in regards to my co-counsel submission, the claimant submits that it is the law of Elirat is to govern the arbitration. And as my co-counsel had pointed out in her submission earlier, it was the respondent for a long who wanted a neutral law to govern the arbitration agreement, which the claimant here agreed. Neutrality is the best choice of the parties or the implied of the parties, pointing to the case of Sulamerica. We are not insisting for Elirat to apply here, but we are merely upholding the party's intention ultimately, and this reflects the spirit of arbitration where parties' intention are out of primary consideration. And having said that, the respondent is going against everything they have agreed upon. And for these reasons, Elirat, given its neutrality, should be a proper law governing this arbitration agreement. Panel of arbitrators, I rest my case.
Thank you. Sorry, Butler. 2 minutes.
Thank you so much, Madam Presiding Arbitrator and members of the tribunal. The council now would like to move towards the rebuttals. Firstly, the council would like to request the tribunal to refer to paragraph 25 of the clarifications, which provides that during an issue where my client was a leading solar panel supplier in the Salindra solar project where my client earlier applied, due to some issues did come up. However, due to routine inspection, such issues were resolved. So in this case, members of the tribunal, if the claimant had done their routine inspection, such an issues wouldn't have come up. Further, the counsel from the respondent respectfully applied that the Lord Briggs' opinion is a dissenting. However, the counsel would now like to state the case, the recent state case of Charles Lim Teng Siang and another versus Hong Chung Hao and another, where it clearly provides that the NM clauses shall not be effective when there is a clear oral variation. Further, in the same case, in paragraph 50 of the judgment of this case, it provides an exemption to the Lord's assumption approach that was taken by the respondent in their first argument. It provides that the assumption approach seems to be overly concerned with the contractual certainty and seeks to redress the perceived difficulty in proving the existence and terms of an alleged oral variation by excluding the oral variation altogether, even when it has been mutually agreed and proven. Therefore, there was a circumstance, the political turmoil in the state of vows, and that the NOM clause was also addressed by the parties, where they agreed orally to not to sign the agreement. Therefore, the recent case law shall take approach, as it is more recent and has provided an opinion to the law assumption approach as well. Having said that, the Council again would like to submit that the vows model law shall govern the arbitration agreement, as it is as provided in NCAP versus Chubb. The law governing the contract shall be taken into precedence. Further, the pre-arbitration clauses of 30 days was not even fulfilled by the claimant, and merely the contractual terms cannot be ignored when the contract had been signed by both the parties. Therefore, as a matter of fact, the Council would like to rest her case and thank the tribunal. Thank you so much.
Thank you. Handing back to you, Bailiff.
Thank you, Honorable Dr. Mary Lee. So, panel of arbitrator, may we inquire whether you would like to proceed with deliberation session or feedback session first?
I noticed from the rules and regulations somewhere that you actually wanted us to give our feedback immediately to the oralists, and then recess to deliberate. This actually doesn't, is quite different from the usual way we do things. We deliberate and then we come back and we give our comments. I stand guided. Did Mr. Ravindra and did Crystal, did you notice that?
Well, I hadn't really noticed it, but I have to say I agree with you that I would prefer to deliberate first.
Yes, we would like to do that. Could everybody take I think we'll need at least 15 minutes, isn't it?
Yes.
We'll take 15 minutes. Everybody can go away happily. It's 11:40 now. Give us 15 minutes, about 5 minutes to 12. We will come back and then we will share our thoughts.
Sure, Honorable Dr. Mary Lim.
Just call me Dr. Mary, and don't need the honorable. Otherwise, it would be it's Monday morning.
All right, Dr. Mary. So, panel of arbitrators, kindly give us a moment, as our technical team will now assign you to the breakout room. And
yes, please.
Yeah, sure.
And the rest of you can go and look after the dog and break 15 minutes. See you later. Thank you.
See you later.
Where's our room? Ready? Kai?
Yeah, give me a moment. I'm opening.
Yep. Thank you.
Dr. Mary and Mr. Ravanta.
Yes, would.
Sure. As a gentle reminder, councils, please stay in this room, as our feedback session will take place later. Thank you. Teams and arbitrators, we will now proceed to the feedback session. The floor is now passed to the arbitrators. Mr. and Madam arbitrators, please. Dr. Mary, you are muted.
Thank you. Sorry about that. Dear Mooters, thank you very much. What a way to begin the last day of the month of May before Malaysia goes into complete lockdown tomorrow. Some of you are in better places than we are. We can only dream of it. What we're going to do is we're going to share with you some of our thoughts on your performances, and I think that's what you would like to hear. May I invite, first of all, Mr. Revada?
Thank you, Dr. Well done. Mooting as a student is a really daunting thing to get into. And I must congratulate all of you for using this opportunity to hone your legal skills and your oratory skills. That's really very good. And to be quite honest, it pushes you beyond what you normally do in your day-to-day university career. So having said that, I'll just run through my thoughts on your performance today. So Clarissa, I thought you did a good presentation, and I felt that the substance of your presentation was good, and you were responsive to questions. So well done, and keep doing this mooting business. It will ultimately result in you becoming an excellent lawyer. Radhashri, if I may call you that, I thought you had a really good style in making your presentation. There was a firmness in the way you dealt with the arbitrator's questions, and you were believable, shall I put it that way. You didn't expose too many inadequacies in your arguments. I thought that you made your points well. I have to say that the firmness that you displayed will go a long way in your future career. Priyansi, I must say that you were competent, engaging, and interesting in your presentation. You dealt with the law and the facts quite well. I feel that, perhaps the mood problem was a little one-sided in your favor, but you made full use of that. And
Amusing.
Well, sorry?
I had a slight interruption.
Yeah,
I'm not sure about this experience, yes.
Yeah. Okay. So Alankrita, once again, great style, very responsive to the questions. I'm going to just make one point that, well, perhaps 2 points at either end. I think you speak too fast. If you take a more measured approach, you will find it easy to make your points. It's easy for you to understand the impact you're having on the arbitrators. And, you know, at the end of the day, you'll find it easier to deal with questions if you take a more measured, paced approach. On the other side of the spectrum, I think you did a great job with setting the scene and explaining the position of your client really well. And while the mood problem may have been, again, you know, balanced in a little in your favor, you made full use of that. So well done. What I'd like to say in conclusion is you all did a great job. Pat yourselves on the back and enjoy the rest of this moot competition and your future careers as lawyers.
Thank you. Crystal.
Okay, I'll just keep it simple because Mr. Raman already said quite a few bit. Starting from claimant number 1, Carissa, I think it's good effort and we can see good preparation on your end. However, if I could use a sheet or maybe time to come and focus on the questions that the tribunal is asking. So perhaps when answering questions, same as what Mr. Raman already mentioned, take a step back, think through whether the tribunal is actually asking a question which is helping you to find an answer or directing you to the area that the tribunal is actually thinking. So that may actually help you in framing your answer and taking the pointers actually gave by the tribunal. So that may be something that you want to focus on in your next practice. Claimant number 2, I must say, well done. You are able to engage with the tribunal. You stay very pointed and collected throughout the questioning session by the tribunal. So I really do enjoy the conversation with you. One of the points that I think Dr. Mary asked this particular question about damages to you, if I remember correctly. I actually, when Dr. Mary mentioned during our earlier discussion, I actually think that perhaps preparation-wise, you can venture beyond the help of your lecturers or your peers within the university. You can actually reach out to certain practitioners, perhaps in this particular area, because the question is very interesting. It's involving renewable energies, and also is one of my practice areas. So I can right away see the answer to Dato's question when Dato was asking us, what is the damages? What are the potential damages to an energy producer, energy generator? So apart from EPC losses, what is it to your local council when you are able to generate electricity with gap availability capacity payment? That is your revenue. So these are some of the things that will assist you in preparing your moot, and I think Dr. Mary will tell you more about this later. And then to Priyansi, good job, because you're the first to speak in the entire session. You're very, very collected, speak well, and I can see your confidence when you speak. I love it. You're able to answer questions, but one thing that you can strengthen perhaps is your referencing and understanding of case law. So apart from just quoting, as per this case, maybe you can pick and choose some of the case on point, venture into it, and tell a little bit more about what was decided, how it can actually be applied to our particular case. And respondent number 2, Alan Kritar. Interesting, very interesting opening remarks. But if this is already in your written submission, you may want to tweak a little bit so that it doesn't seem that you are memorizing from your written submission. Because I read your written submission and your opening remarks quite mirror your openings, your written submission. But it's still very, very interesting when you, I would say, recite it, but when you present it. And last question is something that I learned as well from one of the leading arbitrators, or also leading female arbitrators. So that Lucy also told me the same thing as what Mr. Raman told you earlier. Stay collected. Try to whenever there's a question posed to you, whether you know the answer, you don't know the answer, stay collected. And when you reply, pace it. And don't smile. You didn't really smile, but don't smile. Pace yourself. Reply in the tone of your usual tone, meaning your opening remarks tone. if you can just use that term throughout your submission, that would be a very, very good submission. Yes, that's all.
Oh, thank you so much. I'm sure all of you, not just the Bailey, Jaden and all, are listening intensely on these, on the feedback. I'm sure they'll take away and think whether they will want to take part in the future. Please take these contributions from us in a very positive light. They are meant to encourage you. Thank you so much first, each one of you, including your researcher who must be frantically scribbling a quick answer, intelligible answer for you to respond to these horrible interventions, particularly coming from me, when sometimes it becomes a bit gobbled and you need to ask them, what are you talking about? I can't understand. Would you just reduce that to simple English? And that's exactly what happens, be it in court or in arbitration. We have a thought and we need that concern clarified or emphasized. So that's exactly why we ask intervention. We do interventions, not to derail you in your arguments, not at all. They are, as you would see when you come to court, when we ask questions from the bench, it is to clarify, affirm, and to echo what the other side has said, to see whether it makes good sense and good law. I echo all that have been shared by Mr. Raventha, who's all the way in the UK, and Ms. Crystal, who is here in KL itself, I believe. They have given you very, very positive remarks, which are meant to encourage you. Do take it in that light. When you make your oral submissions, it's dynamic. It's very dynamic because you may have prepared your text and your responses. You've gone through the problem so many times, but it's very dynamic because of the interventions and because sometimes a read becomes slightly different. So what you must do, whether you are in arbitration or in court, is always to listen. Listen to yourself as you speak and as you respond and as you listen to others when they're making their submissions, and then you always take advantage. Concessions were made by the respondent insofar as jurisdiction is concerned. Immediately in your response and said, well, I thank my learned friend for having taken this position, but don't stop there. We say this and that. So when you take your approaches in that manner, it shows that you are engaged, you are involved, you are present in the arbitration, and not as if two ships that are just passing in the night having their respective journeys. You are in the same quest to be the best team and the best oralist and whatever, and to become the best lawyers ultimately. So lawyers are only good when they know what they're talking about, and you can only do that if you listen to what you say and that it is a response. So you must always remain prepared, be holistic in your preparation, be very practical. You have to know the law. You do have to read it quite comprehensively, and it is not easy. Commercial international arbitration, the numbers, the figures that talk to you, they are case
Dr. Mary, it seems like Dr. Mary is having some technical glitch. We'll reach out to her. So shall we grant some time for Dr. Mary to fix her technical issue, please?
Sure.
Makes sense.
Ms. Wong, do you want me to text Dr. Mary?
Yes, sure. Hi, Dr. Mary. Good day, Dr. Mary. Can you hear me and see me? We'll give some time to Dr. Mary to adjust her internet problem. Thank you for your patience.
Can you hear me?
Yeah, loud and clear.
I'm using my handphone now. I've got 3 devices on. All right, I'll quickly get to the point. You can see, you just need to be very practical. Punishing can let you down, and that's so you have to be prepared. You have to take every measure. And now I can't see you. Okay, right. So basically, thank you very much. As far as the individual oralists are concerned, I have made my responses in the written feedback. So is there a variation to the remarks, or we now new contract? I must congratulate each one of you. The interventions can be painful, but each one of you have remained extremely calm, even to the point that, sometimes you can't understand what the question is, and it happens. You've maintained your composure, you have remained very polite, and that is absolutely important, regardless whether you're dealing in courtroom settings or in arbitration. But I think there's the one thing you all could do to take away, other than the other remarks that have been shared by my colleagues, is that I think you should have better tone and modulation of your tone and the way you address the arbitrators. This is not a moot in the sense of, you see, you are talking to us, you're trying to persuade us. So at the end of the day, it's how you look at us in the eye and speak to us where we can understand what you're talking about. When you read off, we immediately can tell that you're reading. When you are speaking, perfecting the way you're speaking, but not persuading us, we also can detect that. And what the courts and the arbitrators look at the end of the day is a discussion. We're entering a discussion to find a resolution to the dispute. So it's very important that when you deal with advocacy, it is not about perfection, but it is about communication. And you should use this virtual platform to that advantage. it allows you that kind of playback and the opportunity to improve on the skills. You already have the rudimentary skills. You have, most of all, courage. You need tons of that in order to get this far, and the stamina to withstand all the interventions from the different types of arbitrators that you've got. So you've got half the battle in your pocket. The rest is now to hone it, taking into account the remarks and the thoughts that we've shared with you. Take them positively. We don't perhaps have as much time as we might have had. May I, if the organizers do not mind, I would like feedback from the four of you to tell us how you have experienced, how your experiences were, and how you felt about the interventions, or how we could have avoided those interventions. Could you do that? Would the organizers, would that be all right, Believe?
Sure, Dr. Mary.
All right, thank you so much. So may I invite the response of our colleagues, Priyansi? You were the first mooter.
Thank you, Madam Presiding Arbitrator. As a whole, I felt very happy, first of all, because we've put on so much of hard work for our written submission, and for orals, we have everybody, like even the side of the claimants, they have performed really well. All of us have really worked hard. So my experience as a whole was, I loved the speaking with the tribunal, and I personally felt that the questions you asked, or even the other members of the tribunal asked, even helped me make my argument or my pleadings better. So the intervention were not as such that it's bad. No, it was wonderful. So it was wonderful having you, and I'm very happy that I got an opportunity to place my oral pleadings in front of you all.
Thank you. Thank you so much. May I invite Alan Krita?
Yes, thank you so much. So firstly, I felt really good because I got a very constructive feedback due to which I could improve in days to come. And regarding the intervention, I believe that when intervention takes place, then the tribunal wants to know more about very precise, and I love the interventions, as the interventions actually, it shows that the tribunal is trying to understand what we are actually trying to say. So as a matter of fact, I enjoyed the interventions and I got to learn a lot from it. So thank you so much. It was a pleasure pleading in front of all of you. Thank you.
There is only one small remark I want to make about your written submissions. Somebody wrote it and used the word vividly, repeatedly. It's a very unusual word to use in legal submissions. I rarely come across it. I'm not sure if that was picked up by my colleagues. Crystal, you're nodding.
I mean, usually if you use it once or twice, and usually that word, I think orally when you speak, you use it, but then in written form, not really. But the problem is, it's basically like what Dato mentioned. If this keep repeating, then it seems to be like, we don't encourage repeated usage of descriptive words. Yeah, that's one thing. But yeah, I saw it, but then I didn't pick it up.
Thank you. Thank you so much. Can I invite Clarissa?
Yes, madam. Throughout this competition, it has been a very knowledgeable, educational experience towards me. And also throughout all the stages in this competition, it was very challenging to meet different opponents from all different universities, and not to deny they were actually also good. It was a very intense argument from every side. And to make it this far, I'm so grateful, and especially being judged by three amazing people here, three amazing judges here. And yeah, and I got the feedback, and I intend to take all the feedback and work on it. Therefore, I'm so grateful for this.
Thank you so much. And Rajashri.
Yes, Dr. Mary. This experience was really amazing. And as a first timer, I think I learned quite a lot, not only from the panel of arbitrators, but also from my opponents, because I have to say they are quite good. And they really gave us a good competition, a tough one. And especially your questions regarding about the damages. I think I understand my loopholes in my submission, and I'll definitely join more mooting competitions in the future. And I will definitely keep in mind of your comments.
Thank you so much. Congratulations, every one of you. I apologize for that glitch that we faced just now. And thank you so much for making it so interesting. It's been a learning lesson for each one of us, for me especially. Thank you so much. Over to you, Bayleaf.
Thank you so much, panel of arbitrators, for the constructive feedback. Before all of us exit from this breakout room, we would like to have a photo session to commemorate on this mooting competition. So we'll count to 3 before taking a picture. Everyone ready? 1, 2, 3, smile. 1, 2, 3, smile. Thank you so much, participants. We wish you all the best. Dr. Mary Lim, Mr. Rivanta, Sunita B, and Ms. Crystal Wong Wai Chin, we appreciate your presence today. It has enabled us to ascertain the quality of the ICAMC 2021 and provide a fruitful experience to our participants. Wherever you are, stay safe and take care. Once again, thank you everyone. You may leave the Zoom meeting now.
Thank you.